This is Michael Popok, Legal AF. I just had the pleasure of interviewing J. Michael Luttig, former federal appellate judge, shortlisted for the United States Supreme Court, conservative icon and firebrand, and defender of the Constitution. And he is beside himself with what he just watched the quote-unquote conservatives, small c conservatives of the Supreme Court just do to our delicate balance of power, checks and balance system, separation of powers, whatever you're going to call it. There are no longer co-equal branches of government. We now have a one branch that reigns supreme as an imperial president as a result of this ruling, when all they really wanted to do was to benefit one Donald J. Trump, and the burdens they have placed on the prosecution for future prosecutions of people named Trump or otherwise makes it almost impossible for any official conduct or core presidential conduct to ever be subject of a criminal prosecution ever again. Tune into my interview right now with J. Michael Luttig. I took slight solace in that, again, a lot of drive-by references to major constitutional principles, which shows you how sloppy this decision was, because as you said, it's reversed engineered to back into the result that they wanted. So on page 7, Chief Justice Roberts says, if the president claims authority to act, but in fact exercises mere individual will and authority without law, the courts may say so, citing Youngstown. In Youngstown, we held that President Truman exceeded his constitutional authority when he seized most of the nation's steel mills. But once it's determined that the president acted within the scope of his exclusive authority, his discretion in exercising such authority cannot be subject to further judicial examination. And by the way, you can't look at motive. And by the way, we're going to limit the amount of evidence you can put on against the person at all. And if you have anything left, that's a prosecutable crime. Judge Chutkin, good luck with that, and we'll see you back on another appeal. That's the way I read this.
Well, and of course you're right. Well, Michael, the entire opinion read like a first-year moot court brief.
I wrote one of those.
before the moot court argument
right.
on this very case. It was sophomoric, and it was childish, frankly.
So let me run a couple of scenarios by you that is keeping our audience and me up at night. I mean, frankly, when you were listing all of the scourges on the court and the decisions, when you got to Korematsu I literally got my hair on the back of my neck stood up. Because you're so right to put it in that kind of historical perspective. And I'm hoping that future Supreme Courts in the right hands are going to fix this mess that's happened now. But we got to live with it for the time being. When they say, well, for official acts stretched to the outer perimeters, we're going to give a presumption of immunity, but we're going to allow the prosecutor to try to prove that the applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. Okay, so in exercising and this is even core, this is pardons, pay to play. Trump gets back into office, decides to sell pardons. Can we prosecute that?
Of course not. And you're brilliant, and I don't need to tell you that. But the passage you read is the passage that I read out loud to my wife twice, minutes after the decision came down, and I told her, this is the sentence that proves that the court has now given absolute immunity to Donald Trump for any crime that he committed and any crime that any president commits. Because as your question suggests, it is impossible, given the nature and scope of presidential powers, both constitutional and by law of the United States, to ever prove to this court's satisfaction, to be sure, that there would be no intrusion on the executive's powers.
Right. Right. Once you have core, which is still ill-defined here, even though it's sort of like obscenity. We know it when we see it. We used to think so. But now when you have to have that as your major first touchstone, yet it's not defined, which is what you're saying, and then you stretch official conduct like silly string, silly putty, as far out as possible, all of those overlapping circles for the Venn diagram, how could a prosecutor ever overcome that burden? So even though people, are thinking, well, maybe it's ludicrous. The drone strike of your opponent would clearly be outside the outer boundaries, or wouldn't be core, or would exceed constitutional authority. I don't know about that, based on lack of motive, motive can't be proven, limited evidence on official conduct, and this standard. I'm not so sure about that anymore. What do you think?
No, you're justified in at least being unsure. Most constitutional commentators that I've read in the past 3 or 4 days have not been so equivocal. They have stated their view that drone strike would be immune from prosecution. And I certainly believe that it would, based on the literal words of the Supreme Court's decision. It's there. Look, this was beyond astonishing. It was stunning. Never before in 250 years of our history, Michael, has anyone suggested that a president would be immune from prosecution for any crime at all. This whole dichotomy, if you will, between official and unofficial acts of the president, which is made up out of whole cloth. Your viewers and listeners must understand there is nothing at all in the Constitution of the United States that supports this ruling. There is nothing at all in 250 years of Supreme Court precedents that supports this decision. And it's contrary to American democracy, the Constitution, and the rule of law.
The framers, as just to carry forward the logic of your point, Your Honor, the judge, the framers could have, with their quill pen, written in an immunity for the executive branch. They did it in some other contexts. They knew how to do it when they wanted to do it. They didn't do it here, because I think that is anathema to the delicate balance of checks and balance. Congress in the sphere of making legislation. Yes, dutiful, faithful execution of it is in the presidential sphere, but everybody has to, in order for there to, if there wasn't a concept of checks and balances, I would think, all right, they're just 3 co-equal branches. But what happened to the checks and balances? And if you put somebody above the laws of Congress, which are the criminal laws that we're talking about, and give him immunity for obvious criminal conduct, how do you possibly rebalance? You haven't. They've accomplished one of their articles of faith. They have supported the creation or the reformation of an imperial president, a Leviathan who sits above the government like an eagle instead of being a co-equal branch of the government.
They have resurrected in America a king. It's just that simple. Yesterday was Independence Day, and I was so struck by the juxtaposition of July 4th with this opinion that I wrote something to the effect that it's a cruel irony that the Supreme Court decided Trump against the United States only 2 days before Independence Day 2024. America fought, and Americans fought, a revolution against the British monarchy and the ruling King George III over 250 years ago in order to secure this nation's independence from the British Empire and to establish a constitution and a rule of law under which a king would have no place whatsoever. And only 2 days before Independence Day 2024, the Supreme Court reanointed, if you will, in cruel irony, the President of the United States as king. And it was not just the President of the United States, Michael, it was Donald Trump.
Welcome back. That's what we do. We curate the top 5 stories at the intersection of law and politics and bring it to you on the MeidasTouch Network 2 ways, Wednesdays and Saturdays at 8 p.m. Eastern Time. I co-anchor it on Wednesdays with Karen Friedman-Agnifilo and on Saturdays with Ben Meiselas. And then we do hot takes like this one and interviews like this one all along the way to keep you updated in real time at the intersection of law and politics. If you like what I'm doing, leave me a comment and a thumbs up. You can find the full-length interview that I did of J. Michael Luttig on the MeidasTouch Network on our YouTube channel, for sure. And if you have an opportunity, leave a comment, leave a thumbs up. It keeps us on the air. It signals to the algorithmic gods that you like what we're doing on this network, and we're building it with your help, with our bare hands. So until my next hot take, until my next Legal AF and or interview of J. Michael Luttig, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.